There are concerns of a drop in efficiency standards at the Constitutional Court. According to norms and standards stipulated by Chief Justice Mogoeng Mogoeng, the average time of a case from hearing to the delivery of a judgment should be about 3 months. But an analysis of about 182 matters before the court from 2019 to March this year show that the average is at about 6.5 months. Judges Matters says Chief Justice Mogoeng Mogoeng should either propose that the norms and standards be amended or ensure that, in fact, they are adhered to by the Constitutional Court. For more on this, let's bring in Zikhona Ndlebe, who's a research and advocacy officer at Judges Matter. Zikhona joins us via our Zoom link in Cape Town. Zikhona, thanks for your time. Welcome to the AM Report. From your analysis, why are these cases taking so long?
There cannot be a reason provided by us, Ayanda, as to why these cases are taking so long to be, judgments are taking so long to be handed down by the justices of the Constitutional Court. But what we've heard from the spokesperson of the judiciary, Ayanda Nyathi, is that the reason why the judgments are handed down so late, way after 3 months, is because of the 17th Constitutional Amendment, which came into effect in 2013. But we cannot accept that as a valid reason because the 17th Constitutional Amendment came into effect in 2013, and it has been years now since it has been in place. And just after the 17th Constitutional Amendment came into effect, the norms and standards were adopted by the Chief Justice and the judiciary in 2014, which state that judgments must be handed down at least within 3 months. But over the period of time, we've seen that that is not happening. But it is quite a concern that this is coming from the Constitutional Court. There have been concerns at the various high courts. But once again, the Constitutional Court should be leading by example, but that is not happening at this point. And we have not been provided with valid reasons. And the fact that the 17th Constitutional Amendment came into effect in 2013, it is not a valid reason at all.
And of course, you know, there's that saying, justice delayed is justice denied. For those people who are struggling to connect the dots about why this is problematic, take us through, you know, the possible consequences of having cases go on way longer than they should.
It is correct that justice delayed is justice denied. You must bear in mind that when dealing with cases, you're not only dealing with files or papers, it's people's lives that are at stake, and having to wait for a judgment to be handed down for longer than 3 months after you've had to wait for months just to get a set down date, which is something that happens in our courts, within our judiciary. It takes time to get a set down date, and once you've had a set down date and your case has been heard, now you have to wait for 3 months, which is the maximum time that you're supposed to wait. But as we've seen, 3 months the justices are not adhering to the norms and standards. And what is of concern is that the Chief Justice in the JSC, he raises this question when candidates are being interviewed. How long do they take to hand down judgments, and how many reserved judgments do they have outstanding? And he makes it a point that candidates are aware that they're supposed to hand down judgments within the period of 3 months. But now the Constitutional Court, once again, is not leading by example, and it's people's lives at stake. People have to wait, for example, the Predwin case for a year just to get a judgment at the Constitutional Court. That is unreasonable.
The suggestion here is that either the norms and standards are adjusted, or Chief Justice Mogoeng Mogoeng ensures that the Apex Court simply adheres to these standards. If the first option is to be taken, what kind of amendments do you think can be introduced?
Well, the only reasonable amendment at this stage would be to extend the time period within which judgments must be handed down. If not, then the justices at the Constitutional Court and the judges at the other various courts must adhere to those standards. But once again, the Constitutional Court is well resourced. It has researchers available to the justices. It has a well-equipped library for the justices. So again, we have not been provided with a valid reason as to why the justices are not handing down their judgments within a period of 3 months. Extending the period of 3 months, it's something that is possible to do, but what impact will that have on the general public and the people that approach the Constitutional Court to have their cases determined by the justices at the Constitutional Court? That means that they will in any event have to wait for longer than 3 months. And the question, would that be fair? That's the question at the end of the day, that people have to wait for a long period of time just to have their cases heard by justices and then have the norms and standards, the period of 3 months extended. And in our view, it's something that can be done, but we have to consider the people that approach the Constitutional Court and the high courts, the superior courts, basically.
And as you're speaking now, I'm actually thinking, I wonder what informed the decision to have that time stipulated at 3 months to begin with. But do we have a handle on how we're comparing with our neighbors on the continent and perhaps on the world? Typically speaking, once a case reaches the Constitutional Court, and not all cases do, how are we faring insofar as how quickly we're able to resolve those matters?
Well, in other jurisdictions, it would be fair that they are being resolved timelessly. And in our view, 3 months, it's sufficient time in any event. So extending that time would delay justice once again for those people who approach the Constitutional Court. And you must also bear in mind that the Constitutional Court is the last port of call for people. After a judgment has been handed at the Constitutional Court, there's not much that can be done afterwards. So having to wait for an outcome for longer than 3 months, for 6 months, for a year, only to find out that the case has not been decided in your favor and there's nothing you can do about it, it's quite concerning.
But given that, Zikhona, don't you think the stakes are much higher? And, for instance, we might run the risk of pressuring the Constitutional Court to make decisions that are irreversible because we feel like they're taking too much time. I imagine part of the defense will be this is a decision of no return and will need as much time as it takes to reach those decisions. What's your response to that?
Okay, but we fully understand that. But now you must note that the norms and standards specifically state that save in exceptional cases where it is not possible to do so, every effort shall be made to hand down judgments no later than 3 months after the last hearing. Obviously, we want justices to fully consider cases and not make rash decisions because they want to hand down their judgments within the period of 3 months. But as I've said, that the Constitutional Court is well resourced. It is better resourced than other superior courts. So handing down a judgment within a period of 3 months should not be a huge issue. Obviously, we want justices to fully consider cases, but there is a leeway. If a case is it's quite complex, if the papers are voluminous, then it could be acceptable that a judgment will be handed down after the period of 3 months. But having a judgment handed down after a year, such as in the Pribune case, and that is not reasonable.
All right. Well, thanks for your take on this issue. I imagine a whole lot of people will also be weighing in the legal fraternity. Certainly appreciate your insights. Zikhona Ndlebe is Research and Advocacy Officer at the organization Judges Matter. Thank you very much indeed.